my community activity. Community activity and public service is a very strong value that I have held and lived by my whole life. In addition to working on gun violence reduction, I've served on the San Francisco Police Commission, and I've also served on the San Francisco Ethics Commission, and as president of the San Francisco Women Lawyers Alliance. While on the San Francisco Ethics Commission, while I was president, we got passed partial public financing to rein in some of the expenses for running for office in San Francisco. When I was on the San Francisco Women's Alliance Board, when I was serving as president, we created and got installed into the Hall of Justice a children's waiting room, because we felt passionately that children shouldn't be in criminal courtrooms listening to the business of their parents. And likewise, now there's another children's waiting room that the Alliance brought about down in the City Hall courtrooms, and that's available to jurors as well as to parties. So here again, it's a service that for the community who has business in the courts. My qualifications for a judge. I have been really growing into this job all of my life, and most recently in the past 30 years. I have over 30 years as a law professional, and there are three things about my experience that is particularly notable and unique. Of those 30 years, 20 of those years are working as an advocate, representing clients and their needs, advocating for their needs. The second thing that is important to understand is that the breadth of my practice, I have both criminal and civil law experience, but the bulk of my experience is in that civil area, and I have experience on a large cross-section of legal matters, including contracts and business and partnerships, employment, real estate, construction, trusts and estates, and so on. And the third, and probably and especially the most important, I believe, is that for the last 10 years, my work as a mediator and arbitrator and a hearing officer with the San Francisco Police Commission has allowed me to use the very skills that a judge needs in the courtroom. Listening carefully what the parties have to say, evaluating the evidence, weighing the evidence, helping parties resolve their conflicts, making tough decisions. Example of tough decisions, the police misconduct cases. Part of the job as a police commissioner is to be the hearing officer on serious police misconduct cases, and then also to decide on guilt and penalty on those cases. This is a very tough job to do, so I have experience making these tough decisions. So I would bring to the court, and would like to have the honor to bring to the court, my personal experience as a victim of a very serious violent crime, the experience of being a single mom to a young boy for his whole life, a business owner. As the owner of my mediation services, I know what it's like to be a business owner. In small law firms, I know what it's like to be responsible for the well-being of employees and training them, and for client matters and running a business. I know what that's like, my community service, the integrity of my working on my values and bringing that into the community and public service. And then finally, 30 years of experience in the legal profession, both as an advocate, but also as somebody who is working as a decision maker. And I think that that is an especially important feature in a judge and an important experience that I would like to have the privilege to bring to the court. I can promise you this, as a judge, every party that appears before me will be treated with respect, will be treated fairly and justly, regardless of who they are, what their background is, what they look like, or their socioeconomic status. I thank you for listening, and most importantly, I'm anxious to hear from you what you perceive the needs are in your community and how the judicial system, how our courts in San Francisco can help you and what you think they could do to provide better services to you. I know one thing, on the bench, I would be working very, very hard, as demonstrated by my work history, and I would be able to work very, very efficiently because I have 10 years of experience working in a quasi-judicial capacity. So again, thank you very much. My endorsements, partial endorsements, are listed on the page here. I think it's more important that we go directly into your questions, so I don't want to take up any more of your time. Thank you.
We're really lucky to have two really dynamic, hardworking, caring, and qualified candidates with us. So we'll take the next 10 minutes or so to take some questions from you guys. We'll hear it, and then I see David.
What do you think about harm reduction?
Sir, did you say
Harm
harm
reduction.
reduction?
Harm reduction.
Harm reduction.
What do you think about harm reduction?
I'm sorry, can you elaborate a little
Okay,
bit?
harm reduction is, harm reduction is when, just like a lot of places, say like AANA, but then there's a new type of program that's harm reduction, meets people where they're at and helps them thus far, partial absence, maintenance.
I can speak to that.
Did I ask the question?
I think I understand the question. So,
Would you repeat your question?
the question was, what are our thoughts on harm reduction as opposed to complete abstinence with respect to substance abuse? So the concept that some people do better having their own program of reducing self-inflicted harm by substance abuse. I personally found it very effective with people that I've worked with. I couldn't tell you exactly how that would play into my role as a judge, but in terms of a member of the community, I've definitely seen some people who would not have been capable at first to completely abstain, to kind of find their own way. And I think it's particularly important, having been a group home counselor, for example, to be able to not turn your back on someone simply because they don't follow the same path that you would.
I firmly believe that we are an evolving culture in terms of how to help people when they're in trouble and have a problem. What works and what works for one person doesn't work for everyone. The most important thing is that it does work for the person that is using it. And so I think that sitting on the bench, how that translates is the framework of the law, which we are constrained by as judges. So within the framework of the law, how does that fit for that individual person and their matter in court? But I think the type of compassion that you're perhaps raising in your question is an important matter on the court. We need people on the bench that will listen to what will work for a person and have compassion.
David's hand.
Okay. Hi, David Elliott Lewis. In addition to being a bench photographer, I'm also co-chair of the Mental Health Board of San Francisco. So this question is about the role of mental health in sentencing, and I understand you follow the law. But when you have a case, a criminal case, where mental illness has played a factor in the criminal behavior, and let's say you could not convert that person to behavioral health board, that was not an option for whatever reason, and so that the case is before you to decide, and there's guilt, or maybe there's assumption of guilt. What is your thinking about how to resolve, what are your values about that when it comes to sentencing, when it comes to applying the law, when there is a strong mental illness factor, contributing factor to that bad behavior? How do you?
Mr. Weiss, you are
David
raising.
Lewis.
Oh, Lewis. I'm sorry, I misheard your name. Thank you, Mr. Lewis. You're raising an incredibly important and difficult question. Our country has been struggling with what to do with people with mental illness its entire history. And as you know, a lot of people historically that would have a place to go don't have a place to go today because our structures have gotten rid of places that they would have gone before. This is a matter that the Police Commission has grappled with, dealing with mental illness on the street in terms of law enforcement. And the officers are now being trained how to be sensitive to people with mental illness and how to appropriately handle situations where somebody is clearly suffering from a mental illness. Now they get into the court system, they've been charged, they're arrested. Again, you're right in pointing out that as a judge, we have these parameters around what to do when a person is charged. Yet, we need to listen to all of the evidence as well. And that you're bringing in an important factor that a judge needs to take into consideration. And he or she will hopefully have strong advocates representing them and this and indicating the state of mind they are in, because that is very relevant in terms of their culpability in certain criminal charges, as you know. But I think that the judicial system in general needs to do more work in this area. I think that both the legislative arm as well as the courts need to work more around sentencing guidelines, and permitting judges to have more leeway in terms of sentencing. Is that okay?
Mr. Willis?
Yes, thanks for the question. I would just add to what Ms. Kingsley said as well, is that as a practitioner and now as a candidate, I'm the only candidate that has been in that situation as a criminal defense lawyer, advocating specifically what my client's mental health issues are and how that has to play a factor into sentencing. It has been quite nice when judges were willing to consider these factors and look to not only see how that factor can play into the sentencing now, but how the sentencing structure itself can be a rehabilitative one that integrates back into society to not only look at what happened in the past, but prevent things from happening in the future. So I'm quite keen on those particular issues. I have fought very hard in many cases to make that be something that is a factor for sentencing purposes. And I would continue to do so, if elected.
Yeah. First, I want to thank the two of you for presenting tonight. As a retired lawyer, I can tell you that it's almost unprecedented that judges engage the communities where they sit. So I thank you for that. My concern with the Superior Court in San Francisco today is the filing fees. It seems that the filing fees are so great. They're denying access to many low-income people. I know you have a fee waiver for defendants in unlawful detainer actions if they qualify income-wise. But you really don't have that mechanism for civil litigation where a low-income person wants to pursue a claim. Your filing fee in municipal court today, I believe, is $370. Many, if not all low-income people, particularly in this district, can afford $370 for a filing fee. So you're denying them access to justice. What are your positions on that particular issue?
Either one?
Okay. I've personally seen that obstacle be something that can't be overcome for many people. The filing fees, not only the filing fees, but to participate in civil litigation, as you know, there are many other fees. The cost of a deposition is $1,000 a pop. Right?
Exactly.
So it makes it very difficult to do that. From a judicial standpoint, some of the things we see, I just kind of consulted with a friend of mine who just got evicted from his place in Birmingham. And in that capacity, you're looking at not only do you have the problem of the cost, but it's also kind of what is at the end of the rainbow, so to speak. Is it a 1 hour hearing in front of the bench? Because a 1 hour hearing, where do you even have the time to fit in all the discovery that you learned in that process? Here today with me is my legal assistant, Paulina, who's had to serve as an interpreter for our clients because the courts don't have interpreters. The budget doesn't provide for Spanish-speaking interpreters or any other foreign language interpreters in restraining order cases, so it's considered an optional thing. I can tell you for my clients who were seeking protection, it wasn't optional at all. You know, but they needed to have someone do it, and if someone was undocumented and did not want to come into court for fear of some type of retaliation, it made it very tough. So I think your point of the filing fees is one element of this bigger budget crisis, but we have very efficient examples of efficient systems. Like the federal system is much more efficient in many different ways, where people don't have to come back to court that often. There's less things that fall through the cracks, and I think the people who are hit the hardest are the poor when trying to get into the court system, because every impact is felt at least 10, 20 times as hard as someone who has the financial kind of stability to deal with it. Part of being a judge and part of what I look forward to if I'm elected is being part of that board of judges that meet every month and talk about policy decisions. So that's where you can say, no, that's not right. I've represented someone in this situation before. And I can tell you that this is what this individual may be going through, and this is why our system can be more efficient in addressing those needs.
Ms. Kingsley, then we have one more question before we move on to the further.
Yeah.
Go ahead, Ms. Kingsley,
Yeah.
then.
I'm not calling you
Hold on,
right.
hold on. One
sorry.
more response to
Sorry.
Tom's question.
Thank you for your patience, sir. I fully agree with the things that Mr. Flores says. It is a very difficult situation, and the administrative end of the courts need to be addressing that, need to be working on that. And I can tell you that I would be working on that in addition to many other aspects of the court to help us run as efficiently as possible. And one of them would be bringing alternative dispute resolution into the court so that perhaps people that can't afford to go through the trials with judges, or excuse me, with attorneys representing them, because there's the expense of the filing fee, but it pales in comparison to the lawyer's fees per hour, which is usually situational, or even the percentage fees, any fees in comparison to the filing fees. So there's this whole problem. But there also is this tremendous resource in the community of people that are trained in the same skills as a lawyer. I help train them. And these people are very generous with their time in helping people in the community work out and resolve their conflicts. So I think that this is something that the courts can tap into this resource and make it available to the community. And then I guess the other thing is we also, on smaller cases, 10,000 and below, in civil matters, there is the small claims court. Even that has a significant filing fee, but it isn't as high and without the expense of lawyers